Hi, I'm James Locke, a trainee solicitor here at CG Professional, and welcome to the latest episode of Coffee and Counsel. In this episode, I'll be discussing one of the most frequent questions we have received from our clients during the Covid-19 pandemic and since the end of the Brexit transition period, namely, whether businesses can rely on force majeure provisions to avoid liability under their commercial contracts. A force majeure clause is intended to relieve a party to a contract from being required to perform specific contractual obligations if an unexpected event occurs which prevents it from being able to perform those obligations. These clauses also sometimes contain termination rights. To rely on this principle generally requires that, firstly, under English law, force majeure doesn't exist as a standalone principle, and so the contract must contain a force majeure clause. This does not need to be called force majeure, but would be any clause that anticipates an event beyond the party's control that may affect performance and relieves one or both parties from performing some or all of their obligations as a result of that event. Secondly, that clause must cover the relevant circumstances, i.e. the force majeure event has arisen. This could, in a case of Covid, refer to a pandemic or epidemic, or, in Brexit, acts of government or import-export issues. Thirdly, the party relying on that clause must be prevented or delayed from performing a specific contractual obligation as a result of that event, and the event must be beyond the control of the party. And finally, that there are no reasonable steps a party could take to avoid the event or mitigate its impact. In addition, any notification requirements set out in the clause or the contract as a whole should be followed, and any timescales in the contract should be respected. For example, if a delay must persist for a particular period before it can be relied on. The most common consequence of a party relying in a clause such as this is the suspension of rights and obligations for the duration of the force majeure event for either or both parties. In practice, this grants the affected party an extension of time for performance until the event impacting its ability to do so ceases. In some cases, however, it can also provide a party with a right of termination if the event is continuing for a specified period. It should be noted, however, that the event in question must actually prevent the performance of the relevant obligation. As an example, a customer whose main obligation under the contract is to pay the charges would actually have to be prevented from paying a sum of money in order to rely on this. For this reason, they are often supplier-friendly clauses, as the supplier will likely have more detailed obligations around delivery of goods and services which may be affected. If the contract does not contain a force majeure clause, the common law doctrine of frustration may apply if, as a result of the coronavirus pandemic, performance of the contract has become legally or physically impossible through no fault of the parties. This is a very high bar, and, as an example of how this can apply, during World War II, many contracts were frustrated when it became legally impossible to trade with the enemy. It is rare nowadays to see a contract frustrated, and this cannot apply if the contract already deals with the situation or the parties should have foreseen the relevant circumstances when they entered into the contract. This latter point may be relevant where a party entered into a contract at any stage after the first COVID lockdown, as, at that point, restrictions of this type would likely be considered foreseeable. At common law, if a contract has been frustrated, it is automatically discharged, i.e. terminated rather than suspended, and the parties are excused from performing their present and future obligations. This means that the contract is brought to an end immediately, but it is not treated as if it had never existed, i.e. where the law may try to restore the parties to their pre-contract positions, and if a contract is frustrated, neither party may claim damages for the other's non-performance. With regards to sums already paid under the contract, there are statutory and common law provisions which apply in relation to the recovery of money after an event of frustration, which can make recovery of sums paid quite complicated and uncertain, but which does, in principle, allow some sums to be recovered for goods and services which are not provided. It is also worth noting that if the parties are relying on frustration, a court does not have the power at common law to allow the contract to continue and to adjust its terms to any new circumstances, and so any variation which the parties can agree would preclude any agreement that the contract is frustrated and should be properly documented. Please feel free to get in touch with a member of the CG team for further advice or guidance if COVID or Brexit is preventing you from performing a contract, or if you have a supplier who is arguing that they are unable to supply. We can review your contractual arrangements from this perspective and provide drafting which helps manage and mitigate these risks, or else suggest an approach which you could take to reduce the risk of a dispute arising. Thank you.